At modern law, you start by doing an initial consultation. So you come in and see someone and talk about what issues you got, what phase you're in, what the areas of controversy, what your goals are, and then you just make a decision either then or not to retain modern law. You are then assigned based upon the person that does the consultation with consultation with Billy Terrazio, who would be the best fit for you. So then you come in for a strategy session and you repeat that process. You start to develop your game plan, and then you usually either respond to a petition filed against you, or you prepare a petition for dissolution or whatever legal documents that you're going. And that is the start of the process. Throughout that process, you go through disclosure and discovery, you go through settlement negotiations. We always reevaluate the strategy and where our end goal is and modify that based upon additional disclosures. So that's the beginning of the process. You do your initial pleadings, then you do what are called mandatory disclosures. You gather documents, you disclose those documents, and then you can do formal discovery, written questions the other side has to answers, or formal requests for them to produce categories of documents. They may send that to you, so you go through that phase. The next phase is the court sets what's called a resolution management conference. That normally is non-evidentiary. It lasts 15 or 30 minutes. Both parties have an obligation through their lawyers to meet and try and resolve some or all of the issues. And the court will typically ask you, and each court handles their own courtroom differently, do you have any agreements, and what can we send this to for a settlement conference through the court? And can we set it for trial, and how much time? So they basically enter a scheduling order for the duration of your court. Then you get to the settlement phase where you try and resolve things. And then after that, if it's been resolved, and at any point up until trial or even after, before the judge sides, you can resolve it if you get an agreement between the two parties. But the next phase is getting ready for trial, filing exhibits, picking out what you want to use, filing your pretrial statement that concerns all your petitions, all your evidence that you got in, and then preparing for trial and going to trial and doing it. Those are the phases.